I don't really want to spend too much time talking about the law. I do think that lawyers have created systems, and I'm historically speaking, lawyers have created systems that are more complicated than they need to be to keep ourselves around as a profession. I get that. However, we have an interesting situation right now where they say, who they is, I'm not, no, I'm just kidding. They say, the province has said that there is an overhaul of the Child, Family and Community Service Act coming at some point. So that act is going to change. What that looks like, nobody knows. I'm optimistic. Let's say I have no expectations, but I'm hoping for the best. Certainly hoping for the best, because it's an older piece of legislation that needs help. We also have the Act Respecting First Nations, Inuit, and Métis Children, Youth, and Families, which came into force January 1st, 2020. So it's almost 2 years now, but we're in a situation where there was no funding provided, right? There were no requirements for funding provided within the new Act. And we have a situation where I'm sure you are all, if not all, very familiar with Jordan's principle, which is, it's not just a recommendation, Jordan's principle, it's a legal requirement that resulted from orders of the Canadian Human Rights Tribunal. So it's not a policy, it's not a program. The point is to eliminate service inequities and delays for First Nations children. Any public service ordinarily available to all other children must be available to First Nations children without delay or denial. And that comes from a principle of Canadian constitutional law called interjurisdictional immunity, which is the piece of the Constitution that says that if the federal government deals with it, the provinces can't touch it, and vice versa. And that is the problem we find ourselves in with the Act Respecting First Nations, Inuit, and Métis Children, Youth, and Families, is that the province and Directors' Council are essentially saying there's no way they can include the principles of the new act in the provincial orders that they consent to or that they ask for in court, because that's not how it works. So there are a number of lawyers fighting very hard, and I'm sure there are a number of advocates as well, and organizations that are fighting very hard to have the new act represented in the provincial system. Again, what that looks like, even 2 years on, just about, right now, nothing specific, but I think it's important to note that funding is required. Funding is required. If nations are going to be, First Nations are going to be putting together child protection agencies, systems of their, independent systems, then they need to have the funding that's required, because otherwise there's an act in place, and that's nice, right? That's nice. It exists. Right now it's, lawyers are fighting to have it included, but it's a fight. It shouldn't be a fight. So anyway, that's my piece on that. I'm always happy when advocates bring up Jordan's principle, when they bring up the new act, and even when they bring up, how flawed the CFCSA is, because it's true. And I think it's something we should all be aware of so that we can work together to make it better. And I'm not going to stop doing that. So, so here I go. Here we all go together, hopefully. Okay. So, Truth and Reconciliation Commission of Canada, as I'm sure you're all aware, final report was published in 2015. So 6 years ago, 5+ years ago, let's say, and calls to action 1 through 5 are on child welfare. None of them have been completed. 8 of all the calls to action have been completed, and none were completed in 2020. And so on the screen here, we've got the slide that's a very brief summary of the first 5. And if you'd like to know more information about what has been done and what still hasn't been done, I make a little note here about the Yellowhead Institute, which is First Nations-led research center based at the Faculty of Arts at what is technically called Ryerson University, is being referred to as X-University now because of how problematic Ryerson was as a human being and the things that were done in the Ryerson name and by Ryerson himself. So just FYI. And their goal is to inspire meaningful action and to hold federal and provincial governments essentially accountable for the failures to create or to complete the calls to action. Another fantastic human being, Sylvia McAdam. If you know her, you know she's great. If you don't, she is Cree. She's a lawyer. She is a staunch defender of land and water. And she's a co-founder of the Idle No More movement, in addition to so many other things. And her passion project currently is to dismantle the doctrine of discovery, which is call to action number 46. The doctrine of discovery is it's essentially the international law that gave license to explorers, in quotation marks, to claim vacant, also in quotation marks, land in the name of their sovereign. So that is how, specifically vacant meaning not populated by Christians. So her work is amazing, Sylvia McAdam. Check it out. Check it out. I won't say too much more about that. She's essentially taking on the Pope in the Catholic Church. So I say go for it. I say go for it, Sylvia. I'm very, very impressed with her. And it's easy to be unimpressed, I think, with government when we have a prime minister who was on the beach on a vacation in Tofino on the first TRC day, right, last week. So if that's the example being made, I think it's good to be looking to people like Sylvia McAdam for guidance in this case. Okay, so the next slide is about, after the discussion, is about time limits. It's all in the Act, the time limits. I think the important thing about advocates and time limits is that you should be aware of them. Lawyers should too, of course. It's, being aware of the law that we're working with is good. But advocates being able to explain why, even though the law says one thing, the reality is another, and I'm speaking about delay in this case, is very helpful because truly, even just across this island, the different periods of time that things take is vast. So that's my note on time limits. And I do like talking about time limits, but I feel like talking about our discussion topic would be a better call.
Okay. All right. I am ready. I am going to drop the fourth scenario into the chat. So you have it. I will open all the rooms now and see you in 3 minutes.
Okay. So yeah, please, everybody, if you can type it in, go ahead. We'll into the chat box, and I'll keep moving, and then I'll keep my eyes back over on the chat box, and we can go back to it because we've got just 12 minutes left. Okay. In my group, we talked about expanding the support team, involving Indigenous organizations in the area if they're not already involved, and seeing if we can find somebody who can assist, not just in a supportive role, but maybe tracking down a different option for care, right? Doing a bit of either family finding or resource finding on our own. The advocate being able to do that. We did not talk about maybe calling the lawyer a jerk, which I appreciate, but I don't think it would be wholly inappropriate in that case, because certainly the law is the law for a reason, and it's one of those changes, right? We need to, family preservation is important. Community preservation is so very important as well. And I mean, in the area that I work in geographically, we've got lots of First Nations who are very involved, which is fantastic. Fantastic. Okay. So yeah, if anyone wants to type, please go ahead, but otherwise we'll move it along. We talked about time limits. Oh, that one, I didn't realize. I must have accidentally, I was like, where are the words? Okay. Oh, contacting the representative for children and youth for the child to have an advocate. Good one. That's a really good suggestion. Jackie. Joyce says, need for information gathering from lawyer and social worker. Why is this the only option? If the child's own nation/band has no one who can care for the child, shouldn't the director consider an alternative nation/band who might have someone able to care for the child? Yes. Yeah, good call. For sure. Yeah, expand the team, right? Expand the team. Okay. All right. So let me just scroll down here. And I mean, if you want to take a look at the time limits in the Act, please feel free. Utilize your local Indigenous justice program. There are 26 in BC. Thank you, Jenna. That's an excellent suggestion. Very good. Okay. So the hardest thing and the thing I like the least, like I said earlier, is just going back to the slides. Oh, Kelsey says, I've gotten things changed when I asked why they were not following those rules. Just talking to the social worker can help. Yes. Advocacy is a strong term that has a bit of fire under it, I think. I agree. Yeah. A lot of times when you know a lawyer is no longer or just isn't getting any traction, for sure, knowing that the mighty community of advocates is going to hear about it is it's very powerful. I agree. Thank you. All right. So as I said, my least favorite part of my job is in the situations where I am advising a client that for whatever reason, whatever group of factors, that maybe consenting to a permanent order is the right thing, or even if it's not the right thing, maybe it's simply looking at the experience of going through, say, a CCO trial for a client, CCO after last chance order, also would be so traumatizing. And the client is at a point where they're going, I just can't do it. I can't be cross-examined. Maybe they've done it before. And they just know that they won't be able to handle it for whatever reason. That's the toughest situation to support a client in. And I need to make sure that my client knows that that I'm hearing their voice, but also that they understand that the thing that I'm telling them is, or the legal advice I'm giving them is, it's not coming from a place of no, or where there are other choices, because we talked about that earlier. And it's not coming from a place of fear. I'm not scared to go to a trial. It's something that when it's the right thing to do, yeah, let's go for it. But I think this is where advocates can truly shine, being able to provide client care after those tough conversations. And we talked about this when we were talking about trauma-informed practice. Like, I can't expect a client to be receptive to me attempting to care for them after I've told them that, that yes, based on everything involved, consenting to a CCO is the way that I would suggest they go. Or after I've accepted their instructions to go ahead with a consent, right? It might not be my advice, but it might be the right decision for the client, and an option that the client has chosen to take. And even, I've provided them with all the information, and I've told them exactly what a CCO means and what their options are for afterwards. I'm not the person they want caring for them. So advocates in this situation, having an advocate involved, especially one that's got a really great relationship with the client, is wonderful. And I'm so grateful when that is able to happen, not for the situation, but for the presence of the advocates. A really cool way for advocates to support clients is in a court setting. Oftentimes, and the better judges, I will say, will ask if the client wants their voice heard by the judge, even if it's a consent to a CCO. The judges will ask, do the parents want to speak? Do they have anything they want me to know before I accept this order? In cases where, especially during COVID, I am not sitting right beside my client, it's really tough to make sure that, I will check beforehand, of course, before court starts. But if an advocate is sitting beside the client and the client doesn't feel comfortable speaking up, there have been a few situations where advocates have spoken to me after the fact, or clients have, and said, I think we should have told the judge this when the opportunity is gone. So I would generally never suggest that anybody blurt anything out in court, except if it's a situation where it looks like things are moving on, and that you as an advocate know that the client has things they would like to share, but they don't have the voice to do it at that point in time. So it's a bit cheeky, but I mean, the worst thing a judge can do is tell you to be quiet at that point. So, go for it. I say go for it, especially if the final order is being made and the opportunity to speak hasn't been presented to the client. We've got 5 minutes left. I do have a slide about applying to cancel a continuing custody order, probably a topic for another day, but that's certainly gathering all the information required to do that is something that an advocate can help with. And I'm always very happy to talk about this with clients, potential clients, because it's important. It's important to know that permanent orders, sure, they're permanent orders, but there is possibility, right? It's not the end of the road. And I've represented a number of clients who have overturned CCOs. And certainly there are lots of bands, First Nations, who are supporting their clients to do this, or sorry, their members to do this as well. So just FYI. And then I'm not going to talk about family law. I know there's a family law section, but it's a way to get creative for sure, especially guardianship. I'm thinking if you can involve another guardian by consent to keep a child out of care, maybe a grandparent, certainly that's an option. Oh, and then the effects of the work. I want to get to the end bit. I think it's important for us all to be aware, right? Apply trauma-informed practice to ourselves. And that means strategies to debrief, being aware, taking a break, having, efficient systems so that you're not recreating the wheel every time you open a file or whatever at your office. So it's important. It's very important, especially because, vicarious trauma, secondary trauma, we're working with clients who are dealing with the worst times of their lives often, but multiple clients dealing with the worst times of their lives. So that builds, right? It builds on the people doing the work. So, rest is important. Self-care is important. Self-awareness is important. Lawyers as a profession, not a very self-aware group. There's the Advocate magazine, which is like the Law Society's magazine. I get it. It comes out 6 times a year, and in it there is a wine column. In the last version, it was the last book. It was 9 pages long, and this is being sent without choice to a group of folks that have some of the highest rates of substance use, alcohol use disorder in any profession, any job, right? So it's one of those things. Okay, so take care of yourselves, please. This is important. Advocate for yourself and those who share your roles to be cared for. That's important. I think this self-care approaches for advocate session, it might be full. I know there are a few that are full. Anyway, check it out. If you're going to do the chair yoga, I invite you to explore the roots of yoga. Make sure it's not just the physical practice that's being talked about, because there's so much more to yoga than that. But it can be a part of self-care. On the 25th, minimizing the impact of stress on the body. Yeah, that session is full. So I'm interested to hear about that from some folks. All right. So celebrate your victories, please. We are always stronger together. That case, the director and DR, I note it not just because it's one of mine, but it is. And I worked with a really great lawyer here in Courtney named Rachel Gutman. The two of us worked together. One of the PLC lawyers, Jeremy Rego, also worked on it a little bit. And it's an example of when a judge is willing to, Judge Flewelling brought a child back from being placed in the interior of BC. The facts are more complicated than that, but in paragraph 70, Judge Flewelling says a removal is traumatizing for a child. That's one of the sentences in the decision. And that's amazing because so very rarely do the judges weigh in on where a child is placed. So it happens. Best interest of the child, right? That's the standard we're going with. So I realize we are out of time, and I am sorry for that because I would like to do another breakout session. However, I think it's more important if the sun is shining where you are that you get out into the sunshine. So on that note, I think it makes sense to move to my very last slide. You can download the PDF of the presentation if you want to just think about your recent triumphs. Please do. Right? If you want to think about the strategies you employ to get the support that you need to keep going in your work, please go for it. I think it's a really good call. So we made it to the end. Thank you. Thank you all for being here. I appreciate it. Appreciate you all for taking the time.
And thank you, Stephanie, for this engaging and enlightening conversation. You've been so generous with your knowledge and sharing such great ideas with the advocates. On behalf of everybody in this group and the Law Foundation and LABC, I thank you for the bottom of my heart for this presentation.
I appreciate that so much. It's been a pleasure, and I'm seeing all of your messages. Thank you, everybody. It's anyone who knows me knows that I can talk forever on a topic that is of interest to me, and this is one of the big ones. Like the fact that I get to do this work in this area, it's both area geographically and area of law is I'm so privileged, and I know that. And I know that white supremacy is pervasive everywhere, and I benefit from it, and I know that. And so being able to use the privilege and the power that I have to do this work and to share, be a part of this community, this conversation, it's so important to me. So as a last note, please take care of yourselves, take care of each other, and know that, if you want to connect, shoot me an email, check out my website, give me a call. I'm around. Take care, everybody. And thank you very much, everyone, for Vinu and Sarah and everybody else. At the Law Foundation. We did all right. We went pretty smoothly. So thank you, everybody.